Hello and welcome to PREMIATNC's YouTube channel. Today, I am going to talk to you about how to close a company in Malaysia. At the end of the video, I will share our contact details. Be sure to contact us for inquiries. Are you wondering how to strike off a company in Malaysia? Sometimes you simply need to close down your business operation in a country due to financial, legal, tax, or competitive reasons. If you find your business in a situation where this becomes necessary, an important thing to keep in mind is that cessation of business should proceed correctly and legally. For the sake of avoiding future tax and regulatory compliance issues, you need to ensure that the government knows you've ceased operations. In order to proceed with this, you have to adhere to the legal procedures for doing so. Striking off a company. To strike off a company needs to request to Suruhan Jaya Syarikat Malaysia, SSM, to strike it off from the register pursuant to Section 550 of the Companies Act 2016. It is a simple and cost-effective method to close down a company, which is relatively quick compared to other options. To be considered for strike-off, the company needs to meet the following criteria. The company never initiated business activities since it was incorporated or hasn't engaged in any business activity. The company has no plans to restart business in the future. The company has no assets, liabilities, or charges pending in the Register of Charges. The company has no outstanding penalty under the Company Act, 2016. The company isn't involved in any other legal proceedings anywhere in the world. The company owes no debts to any government agency in Malaysia. The company isn't acting as a holding company or guarantor corporation. The company has not made any return of capital to shareholders, including dividends. Winding up a company. Winding up of a company under the Companies Act, 2016 can either happen because you've chosen to close your business down or because a court in the country has ordered you to cease operations in Malaysia. These two possible outcomes are respectively called voluntary winding up, VWU, and compulsory winding up by court. Voluntary winding up a company in Malaysia is a more time-consuming, complex, and expensive process than the strike-off process, and for this reason, it's usually less popular. However, if the company doesn't comply with the strike-off requirements and conditions, winding up will be the only available option for the company. For example, a company you hope to simply strike off can't have assets or distribute capital to its shareholders. Thus, if your company does indeed have assets to sell off for distribution of proceeds to shareholders, you would have to legally wind it up. For a voluntary winding up, there are two possible options available according to the law. These involve the following: 1. Members' voluntary winding up. 2. Creditors' voluntary winding up. As for members' voluntary winding up, it applies to a company that is solvent. The members of a company begin the process once the members or directors issue a declaration that the company can pay off all outstanding debts or liabilities completely within 12 months of starting the winding up process. The members' resolution must be passed within 5 weeks after the declaration of solvency by the directors. A liquidator will be appointed by the members at the members' meeting. Once these steps are taken, your company will open a bank account that exists specifically for depositing the proceeds of liquidated assets. As this process kicks into gear, the liquidator also has the job of notifying any relevant parties that the company is being wound up. These people might include auditors, tax office agents, other board members, customs agents, members of the Social Security Organization of Malaysia, the Royal Customs of Malaysia, and other relevant government agencies. The liquidator should also submit regular liquidator's accounts statements to the SSM and to the official receiver, once every 6 months until the winding up process finished. Creditors' voluntary liquidation applies for companies that are insolvent, which is why it involves creditors. Under this option, a liquidator is also appointed, but by the creditors, and as your company is liquidated, any proceeds from the sale of assets are paid off to creditors until outstanding debts have been settled. There is also a section of the country's legal codes that provides you with options for closing down operations of a foreign company's branch office or offices in Malaysia. This might apply if your company is headquartered in another country but maintains operations in the Malaysian market. You need to lodge a notice by foreign company for cessation of business with the SSM within 7 days from ceasing of operation. Upon the expiration of 12 months after the lodgement, SSM will remove the branch office name from the register. If you're going through the process of closing down business operations in Malaysia and would like to make absolutely sure that you follow through with your legal options in a correct and problem-free way, your best option is to request professional assistance. PREMIATNC is a professional consulting, tax and accounting firm that also offers deregistration of your company in Malaysia as a service. Please contact us for a personalized consultation.